Just a quick house cleaning issue. If you have questions, please put them in the Q&A section below, and we'll be taking them up after the presentation. Is everybody able to hear me? You can just type yes in the chat. Awesome, thank you. So, when I first migrated to the United States, there was news of one mass shooting occurring every few months. And now we are at a point that there is a mass shooting occurring every day. And whether we choose to believe it or not, this mounting death toll due to gun violence is now a major public health crisis, one that we are seldom able to have meaningful public discourse around. Do guns kill people, or do people kill people? I'm not sure we'll ever settle that debate, and certainly not in the current political climate. But what we as mental health professionals can certainly do, at the very minimum, is to arm ourselves with information regarding the changing landscape surrounding not only gun violence, but also laws surrounding gun possession, especially when it comes to persons who are afflicted with mental illness. And so to talk about all those vital issues and more, our distinguished visiting lecturer today is Dr. REENA KAPOOR. Dr. KAPOOR is an associate professor of psychiatry in the Law and Psychiatry Division at the Yale School of Medicine, where she is also associate program director of Yale's Forensic Psychiatry Fellowship Program. In the wake of the 2018 mass shooting in Parkland, Florida, Dr. KAPOOR chaired the American Psychiatric Association's task force to create a resource document about risk-based gun removal laws, which are commonly known as red flag laws. More recently, Dr. KAPOOR has worked with the Consortium for Risk-Based Firearm Policy on revising its national recommendations for red flag legislation that resulted in a report that was issued in October 2020. Dr. KAPOOR is currently Connecticut's principal investigator in a multi-state study of the implementation, outcomes, and jurisdictional variations in red flag laws. Please join me in welcoming Dr. KAPOOR today. Thank you.
Thank you very much, Dr. Gulrajani. So let me share my screen. All right, hopefully you guys can see that. If you can't, just let someone know in the chat. So I really appreciate the opportunity to be here today. I'm actually joining you from my office at the state hospital, the State Forensic Hospital in Connecticut. And it's nice to be able to take a break from the daily clinical work of the hospital to talk with you all about something that has been the focus of my advocacy through professional groups and also my research. So our plan for the day is fairly straightforward. The talk is broken up into 3 parts that are in accordance with these learning objectives. So first, we're just going to talk about the basic elements of what a red flag law is, how they work. Then the second part will look at outcomes. We're going to look at the evidence regarding whether they're effective in preventing suicide and violence, and as well as who is affected by these laws and under what circumstances. And then the last part is going to be a little bit of a clinical talk. We're going to talk about the implications for mental health professionals about whether this is a tool by which you can help manage suicide risk, violence risk, and if so, how that actually works in practice. So I don't have any relevant financial disclosures, but I do want to say before we start that I recognize, spending the next 90 minutes talking about gun violence is sensitive and it can be a difficult topic to talk about. in part because we all come to this material with some deeply held ideas about guns, that they are often really closely tied to our values and our identity. And so I'm going to do my best to be respectful of a number of viewpoints. And I just ask that you all do the same, whether it's in the Q&A or in the chat. I'd also just mention that the topic of gun violence and mass shootings in particular is also difficult because these are very tragic events. They remind us of things that may have happened in our own lives. So I just invite you, as you're watching, if you need to just step away. And in this webinar format, nobody will be any the wiser. So as Dr. Gulrajani mentioned in his introduction, mass shootings are a problem in this country. Certainly over the last decade, they have been a source of concern, both for their loss of life and their societal impact. And so this is just a graph that shows you, if you define mass shootings as killing 4 or more people in a public place in one event, these are the numbers that have been present in the US since the 1980s. The trouble is, every time one of these events happens, we have protests on both sides. You know, there'll be people saying guns kill people, other people saying people kill people. And it seems like we go through this where there's an outcry, we say we've got to do something, and then basically like nothing happens with legislation after these mass shootings, and life goes on until the next one. There is one thing, though, that people can agree about guns, and that is that guns need to be kept away from dangerous people. So this is just a quote from the spokeswoman of the NRA, that even the NRA, which typically advocates for expanded gun access and gun rights, says that our position has always been that dangerous people shouldn't have access to firearms. So that sounds like common sense. But the trouble is, and I don't need to tell a group of mental health professionals this, is that dangerous is a really complicated concept. So you've got to figure out, how are you going to define dangerousness? Who gets to determine it? Dangerous to who? For how long? And even little things like, big things actually, about how do you keep track once you've identified the dangerousness, and how do you have the people who need to know about it actually know about it? And so there have been, in this past decade, a number of legislative attempts of trying to operationalize what it would mean to keep guns away from dangerous people. And so the one we're going to talk about today are red flag laws. So red flag laws is the colloquial term. If you read about this in the newspaper, that's what you'll see. There are a number more technical terms. So these are some of them: the extreme risk protection order, gun violence restraining order, which was based on domestic violence restraining orders, and then dangerous persons firearm seizure. There are all these different names for the same idea. And it seems like that the one that's really catching on and gaining some traction is this second one, extreme risk protection orders, or ERPO. So that's what you'll hear me say during this talk, is I'll talk about ERPOs, or red flag laws, and use those terms interchangeably. So we'll start just by talking about what an ERPO is. So it is a law that permits usually police, family members, and other parties to petition a state court in order to order the temporary seizure of guns from a person who presents a danger to themselves or others. So it's a civil order. This is not a criminal proceeding, but it's basically a way to say, I'm concerned about someone I know and their access to guns, and I'd like the court or the police to take them away temporarily until that person is in a better space, and then they can get those guns back. The thing that mental health professionals have traditionally liked about these ERPO laws, or the red flag laws, is that they aren't tied to any kind of particular mental health diagnosis or history. So as I'm sure you know, mentally ill people get blamed for a lot of the violence in this country. And so a lot of the work of the mental health advocacy community has been trying to disentangle those two concepts in the mind of the public, that mentally ill doesn't mean dangerous and at risk of committing a mass shooting. And so one of the advantages of ERPO laws is that they recognize that anybody could present a danger at a particular time, and not just people who are mentally ill or who have a particular mental health history, like they've been civilly committed or they've been incompetent to stand trial. So as of last month, there are 19 states that have ERPO laws, and all but 2 of them, Connecticut and Indiana, passed those laws since 2016. So this is very much a recent phenomenon in most of the country. I think you could rightly describe it as a legislative trend. There are 19 states that have the laws, a bunch of others are considering it. I actually looked at Minnesota, and it looked like there was a bill that was proposed in February of 2020. And then couldn't see what happened to it after that. I imagine it went the way of most legislative proposals during the pandemic, but I don't know if there will be attempts to resurrect that idea in the future. The way that an ERPO law works, just practically at the ground level, is that, let's say I have concern about a family member and their access to firearms. So depending on the state, you can either report that concern to the police or directly to the court, and you ask them to invoke the ERPO law to take these guns away. Then the police might do an investigation to see whether the risk that you have described is actually there. And then they apply for what's called an ex parte or a temporary ERPO. So as you can imagine, these are time-sensitive situations. And so the police don't have days or weeks to think about things. So they act quickly. They seize the guns with this temporary ERPO. And then at the same time, they might take the person for a mental health evaluation to the ER. Depending on the circumstances, they might be arrested and taken into custody. And then the part that's relevant to the guns is that their ability to purchase or possess the guns is temporarily restricted if the judge signs the warrant and finds that there's imminent risk. So that is usually something that will happen like within a day. And because it's so quick, then there's another court hearing, usually within 14 days, where at that point, there's the ability to consider the evidence a little bit more closely. The respondent of the ERPO, that is the person whose guns are being taken away, can be represented by an attorney. They can make their case. And then, the court will either determine that there is risk, and so they will keep the guns usually for a year, but that number varies from state to state. They might determine that there isn't enough of a risk, and so they would give the guns back. And then in some states, they can also order at that time a mental health or a chemical dependency evaluation, though that's not the case everywhere. And then there's, what's not on this slide is that there's a process also by which after the year is over, that someone can apply to renew the ERPO or to just let it lapse, and then the guns are given back to the person. So I know you can't read this. It's okay, because I really just wanted to show you kind of what these petitions look like. So this is one from Connecticut, where there will be this thing on the left is kind of the police affidavit, where they'll say, we responded to the situation. We learned that so-and-so had made suicidal statements and that they had guns. The mother gave us permission to take the guns into custody, and now we are applying for this ERPO in order to keep them in our custody because we think there's imminent risk. And then this thing on the right, usually there'll be some kind of list of what the guns are. Guns, ammunition, and gun parts are the things that they can take. And so sometimes this list is one firearm, and like this one, oftentimes it's many firearms. And then this is what the judge's order in Connecticut looks like. So at that final hearing, they would either terminate the proceeding, meaning give the guns back, or they would order the guns held. And then there's also that box at the bottom that says other, and they can basically do whatever they want. But most of the time it's either give the guns back to the person, destroy them, or keep them in police custody for the year. So if you look at what factors the judge has to consider at that hearing, in Connecticut, there are the things that the judge must consider, which is recent threats or acts of violence towards yourself or others. So that's suicide or violence risk. And then cruelty to animals. And then there's a number of discretionary things that they can also consider, like whether the person was using their gun recklessly, whether they have a history of violence, even if it's not right now, have they misused their gun in the past. They can look at psychiatric history, and they can look at substance abuse as well. And the outcome is that the judge has to find by clear and convincing evidence that the person poses a risk of imminent personal injury to themselves or others. So that clear and convincing standard is similar to what is necessary like for civil commitment. And it's kind of a recognition from the court that an important right, an important civil liberty is at stake. And so we want it to be more than, the evidence has to be more than just equivocal. It has to be clear and convincing in order for the guns to be held. So if you follow this kind of stuff, you will see some common critiques or fears about ERPOs that are expressed in the popular press. So from conservative people, or the critiques from the right, are essentially about the potential for overuse and abuse of these kind of laws. So you'll hear people say, well, how do I know that my ex-girlfriend isn't going to be just mad at me, and so file this order in the court out of vengeance and take my guns away, and that there won't be enough procedural protections in place that could root out that inappropriate use and to protect the subject, the respondent of the ERPO. Then on the flip side of that, you'll see arguments from liberals or people on the left that are concerned about the disparate impact, or the potential disparate impact, that, you know, like all laws, they may not be applied equally to everybody. And so the potential for specifically targeting people of color is certainly there. And then the potential for increasing police contact, which sometimes in and of itself is dangerous, but also then creates a pathway into the criminal justice system that maybe didn't need to be there, or is criminalizing what is essentially a person who was having some kind of like mental health situation or a crisis in their life. So we're going to come back to these things a little bit later after we look at the evidence and see whether these fears are substantiated by the data that we have. So moving into then reviewing the evidence about ERPOs, I should say that there is very little published about this. We're talking about a handful of papers, less than a dozen in total, and they only report data from 5 states. So it's really just kind of what we're going to talk about is me compiling a hodgepodge of studies that have reported outcomes from individual states. And as you can see here, Indiana and Connecticut have had their laws for a longer time. And so they have reported in their studies about findings over, 7 years in Indiana, 14 years in Connecticut. But the other 3 states have all passed the laws since 2016. And so the data available to analyze is very short, a couple of years, in some cases as little as 15 months. And so in total, even if you put all of these studies together, you're still only talking about 1,500 or so petitions that we have to kind of glean data from about how they're being used and how they're being implemented. So that's just my caveat, is that there isn't a whole lot published about this, but I am going to share with you what we do know from those preliminary studies. So we're going to look at a few different things. How often are these laws being used? Who are the people impacted? Like whose guns are being removed? Why are they being removed? Like what are the circumstances? Are they dangerous to themselves or to other people? Because if you keep in mind that a lot of this legislation was aimed at preventing mass shootings, then we'd want to see whether this is an effective tool for that. We also want to look at what percentage of the ERPO petitions are granted by the court, trying to see whether this is just a rubber stamp on police or families' concerns, or whether there really is some kind of due process built in. And then we're also going to look at what happens to the people. Like we're definitely going to talk about what happens to the guns, but equally important, more important, is what happens to the people after these gun seizure events. So are they engaged in mental health treatment? Are they arrested? Like what's the outcome? So we'll start just by looking at how often these laws are used. So they are used really infrequently, I guess, is the bottom line. So if you look at those 5 studies from the states that I mentioned, you can see that, we're talking about somewhere between like 50 and 120 petitions per year on average. And so that's not very many when you think about that there are millions and millions of people in each of these states that have guns. That's a really small percentage. But you could also make the argument that the absolute numbers don't really mean anything, or they aren't the right comparison, because these states also have really different populations. So just to break that down in a different way, that if you factor in population, that's the graph on the right, is kind of how many ERPOs are there per 100,000 people in the state. And then on the right is taking into account that not all the people in the state own guns. So of the gun owners in the state, then what percentage of them are affected or is an ERPO issued on? And so if you look at those left-hand axes, the vertical axis, you'll see that these numbers are minuscule. We're talking about 1 in 100,000 people in a state who are subject to the ERPOs. And, a really, really small, like way less than 0.1% of people when you factor in gun ownership. So there isn't really a whole lot of evidence to support the idea that these are being used willy-nilly, or that it's caught on like wildfire and this is kind of going to be a slippery slope to ending people's Second Amendment rights. I will say, however, that I know from our partners in a research study that Florida, who hasn't published their results, they have a very different experience, that they only passed their law in 2018. And in that time, there's already been more than 3,000 ERPO petitions. So I think we're going to have some interesting things to say about the regional or the statewide variation in how often the laws are being used. So if we think about whose guns are removed, so what I'm going to show you is just kind of aggregating the different states rather than reporting them separately, because they do follow a trend. So whose guns are being taken away? Think about it. The prototypical person is a 40-something, like a middle-aged white man. And more often their residents of rural or suburban areas rather than urban areas. They are people who, for the most part, don't have a history of arrests and criminal convictions. They, for the most part, aren't people who have had domestic violence incidents or convictions in the past. And if you are interested in mental health diagnoses, or what percentage of this population is mentally ill or has a substance use disorder, it's roughly half. That varies from state to state, but roughly half will have had some kind of suicide attempt or mental health diagnosis in the past, or have a substance use disorder either active or in the past. So this is a different population of people than who you would typically find in a mental health setting. It's also worth noting that it's a little bit of a different population from what you think of your prototypical mass shooter, a kind of younger person. And so what we're seeing is that the ERPO process may be capturing a population of people who are in crisis, mostly men who are in crisis for a moment in their lives, and may afford them the opportunity to come into treatment or to get some services, ideally, that they would not otherwise have had access to, or may not even have agreed to. So looking at why the guns are removed, again, this varies from state to state, but the one thing that I want you to pull out from this slide is that harm to self is by far the most frequent reason. So we're talking about suicide risk is usually the reason that the police are taking the guns away. And it's less often about harm to others. And it's even less often than that about kind of psychosis or overt mental illness. That's the reason for the guns to be taken away. And so that's also led to some interesting publications in the past few years that, using a counterfactual analysis, have determined that ERPOs are a really effective suicide prevention tool, in that for every 10 to 20 ERPO orders, that one suicide can be prevented. And so if you think about that in terms of number needed to treat, that's actually pretty good, that, you know, for 10 to 20 ERPOs to prevent a suicide. And so that's led to a lot of enthusiasm, I think, for this as a public policy and a legislative tool. So also looking at kind of who's calling the police or who is initiating this ERPO process, because again, going back to that fear of it's going to be my crazy ex-girlfriend who does this. When we look at the data, what we see is a fair amount of jurisdictional variation, but that usually it's the police. And that may be a little bit of an artifact because we don't know who called the police to begin with. We just know that the police were the ones who went to the court and petitioned for the ERPO. But in Connecticut, where they actually reported who called the police, it's a family member, and then less often an employer, or most often someone who was like a neighbor, a passerby, or simply didn't report. We didn't know who it was that called the police. So I think there's little to say about that yet, other than that we need more investigation. So what percentage of ERPO petitions are granted by the court? So this is another area where only a few of the states have reported, and there are pretty big jurisdictional variations. That in Connecticut, it's more like 3 out of 4 of the petitions are granted, and in Indiana, 63%. In Oregon, my understanding of the reason for those numbers being so much lower is that for whatever reason, most of the time people don't show up to the hearing. So the guns will be taken away temporarily, and then the police officer or the family member won't show up 14 days later for the hearing. And so in those cases, then the petitions are dismissed, and that's why their numbers are so much lower. And I don't know why that's particularly the case in Oregon as opposed to in any other states. But you can see here that, at least by these data, that judges are really considering the factors. They're not granting them in 100% of cases. And in Oregon, not even in the majority of cases. So also thinking about, you know, what happens next. So we have this incident where the person's guns are seized. As I mentioned earlier, the person can be taken to the emergency room for a psychiatric evaluation. And in Connecticut and Indiana, who are the states that have reported this type of outcome data, that is what happens usually. is that the police come, they secure the guns, and then the person is taken to the ER for an assessment of their suicidality or their violence risk. A smaller percentage of people are arrested, and from looking through some of these petitions, usually that occurs in the context where someone has made violent threats towards an intimate partner or somebody else at the scene. And so they have, they get arrested either for threatening, sometimes for breach of peace. They're not, for the most part, serious crimes, but sometimes people do get arrested. And then there's also a subgroup for whom like nothing happens, that they were not in need of an ER evaluation, and they also weren't arrested. So that's what happens to the people, is most of them go to the ER. And then to the guns, usually they end up being held by the police or stored somewhere for the year, and then they can be given back to the individual. And then in a smaller number of cases, they're either destroyed or they're given to somebody else that the person knows in order to safely secure them. So I do want to mention, though, that in the Connecticut data, probably the most promising thing was that when you looked at who among these ERPO respondents actually received mental health services in the following year, the number was almost zero at the time of the gun seizure incident. Like, none of these people were the Department of Mental Health clients. And then if you fast forward a year, that number was up to 29%. And so the conclusion was that the ERPO process can serve as an important portal or entry into mental health services for people who maybe needed that. So the take-home points that I want you to remember about these data are that ERPO laws are used very infrequently. And again, thinking back to those graphs, we're talking about, 1 in 100,000 people in a state, or less than 1 in 10,000 gun owners who every year would be affected by this process. That usually it's white men and in their 40s, that's the average age, though it does kind of skew a little bit younger in some states. That they tend to be people more from rural and suburban areas than from urban areas. About half of the people who are the respondents of ERPOS have a history of substance abuse or mental health diagnoses. So I don't really know what to make of that yet, but I think it's important to note that at least some subset of this population are people who were kind of known to the system. The courts grant ERPO petitions in most jurisdictions in the majority of cases, but as I mentioned, there are some pretty big jurisdictional variations. And then the ERPO respondents, meaning the people whose guns are seized, they're usually not arrested at the time. And instead, they are taken to the ER, and then they may end up kind of staying in mental health treatment for the longer term. So going back then to one of the first slides that I showed you about the critiques of ERPOs, if we look at the evidence and what does it mean in terms of public policy or what people's fears are. So there isn't really any evidence of overuse. Now, I will say that the trend has been upward, that in Connecticut now we have 22 years of data, and certainly you see that a lot more of these petitions were filed after 2012 when the Newtown shooting happened than before. And so it might just be that in the states where these are relatively new laws, it just takes some time to get going. Like, the public doesn't understand it, law enforcement doesn't understand it. And so we may see that those numbers continue to trend up over time. We don't have a whole lot of evidence that this is being abused. For the most part, the cases really have to do with people who have attempted suicide, who have threatened suicide, who have, sent I don't know, a text message to a significant other, holding a gun and saying, you won't see me tomorrow, that kind of thing, where cases where there is real risk. And then the inadequate procedural protections, I at least don't view it that way. I think that when judges are granting at most kind of 3 out of 4 of these petitions, that to me speaks to them taking seriously the idea that there needs to be clear and convincing evidence of risk, and that this isn't just a rubber stamp. And then looking at the concerns from the left about disparate impact, that I think you'd have to answer yes. These laws do affect some people more than others, but it's not necessarily what people were concerned about, that people of color would be the respondents in these cases. It's actually overwhelmingly that white people are the ones who are affected by these laws. And then the concern about whether this was creating a pathway into the criminal justice system, the answer to that is not usually. Depending on the state, it might be 1 out of 5 or 1 out of 10 cases where the person will be arrested. But for the most part, the laws are staying true to their civil nature, and that people are being taken for psychiatric evaluation or medical evaluation rather than incarcerated. So that's all I had to say about the outcomes. And then if you have questions, certainly put those in the Q&A in the chat and we can come back to them later. And I wanted to spend the rest of our time, I guess about 15 or 20 minutes, just talking about what all of this means for mental health professionals, because after all, this is a Department of Psychiatry grand rounds. If you follow gun policy, you will have noticed both in the popular press and in medical journals that there have been a number of articles kind of extolling the virtues of red flag laws or ERPOs. So these are just a couple of examples from JAMA and the Washington Post that, people say that this is a valuable tool for clinicians to prevent gun violence or to prevent suicide. And there's a lot of enthusiasm, I think, for the ability of clinicians to use these laws in their everyday practice, hopefully not frequently, but to become familiar enough that this is another tool that can be utilized. This is just an example of a quote from a physician who wrote an op-ed in the Washington Post saying that he's had great success with family meetings or other interventions to get people to store their weapons safely. But for the minority of patients who are at significant risk of hurting themselves or others and are unwilling to set aside their firearms, that this legal tool, ERPOS, can be life-saving. So certainly it's even physicians who are on board with this. And I guess what I'm going to share with you is my take that is basically also in support of this, but with a number of caveats, and I'll try and explain that along the way. So there are 2 states, Maryland and Hawaii, and then Washington, D.C., where a physician can actually be the petitioner. So most of the time it's law enforcement, family members, intimate partners. And then in some places, just a few, the physician themselves can be the petitioner. The idea being that sometimes it's the doctor who has particular knowledge of the patient, and they may be able to perceive a risk that even the family and certainly law enforcement doesn't yet know about. But if you didn't know that physicians can be the petitioners, or if you've never even heard of this process, you're in good company. So Maryland had passed its law within the last few years, and then there was a study of physician knowledge that came out, and more than 70% of the doctors that they surveyed said no, I'm not at all familiar with how this works. I don't even know what an ERPO is. And so then they did a post-education survey after things had been explained to the docs. And then about 60% of them said, oh yeah, I can see where this could be useful, or at least several times per year, I have a patient for whom this might be a helpful tool. So I wanted to just go through a case example and hopefully illustrate where this gets complicated, because I think so far, all I've really told you about is enthusiastic support and pretty impressive results, at least in terms of suicide prevention for ERPO laws. So I tried to just create a little vignette of a case that probably many of you who work in outpatient settings have seen. So a 45-year-old man who's a veteran and has a history of PTSD and alcohol abuse comes in for a routine appointment in your outpatient clinic and says, my wife told me that she wants a divorce, and starts to say some things that concern you for suicide risk. That's it. I'm taking my guns in my truck. I'm taking off. No one's ever going to see me again. And he doesn't want you to contact friends or family in the moment. So I tried to pick something that was just a situation that most of the clinicians in this audience are going to be familiar with. And it's difficult to know, I think, from this little information, how a case like this is going to play out. It could actually go a lot of different ways depending on what the follow-up assessment is or what additional data that you gather in this clinical situation. So for example, you might hospitalize the person, and then in that case, the issue of what to do about the guns is less imminent, and it might just be something that you would pass on to the inpatient team for them to handle. In where I work, a patient like this, if that's all there was, if you sent them to the ER, there's certainly no guarantee that they would be admitted to an inpatient unit. And so even if you did do that, there might still be the issue of thinking through what's going to happen to these guns and thinking about whether an ERPO petition might be appropriate. And then certainly if you're going to let this person go, that you did a follow-up assessment and you don't think that there is enough of an imminent risk to require hospitalization, but you're still concerned about the guns and him having access to them, then you can certainly think about whether an ERPO petition is appropriate. So there's two different questions here. One is the clinical one that I'm sure all of you are familiar with, about whether we're going to invoke the ERPO petition process. The other then becomes, after you've decided that, yes, I'm going to, then how exactly am I going to do it? So the kind of dilemmas that mental health professionals will face when trying to manage these situations in clinical practice, or the kinds of questions that people have asked me over time, is, first of all, can I be a petitioner? Like, can I request the removal of guns for my patients? And what do I do if they're not the patient's guns? Like, what if they're actually registered to somebody else in the household? Like, how does this work? Also, the issue of how much clinical information should I give to the police? There are no exceptions to confidentiality baked into these laws for physicians. And so it's really a judgment call about how much clinical information to give. What do I do if I'm asked to appear at a court hearing? How do I handle that situation? Should I continue working with the patient whose guns I've asked to be removed? I think that is kind of similar to when you've hospitalized someone against their will, that kind of calculus that goes into whether you can continue to work with them or whether a transfer to somebody else would make more sense. And then also, this has been more of an issue, I think, in the last few years, is that patients come in and they ask their doctors to write a letter saying that they are safe to have guns. And how do you handle that? You know, if we're, let's say, a year out from the ERPO process, what do you do? And the answers have varied kind of from don't do anything all the way to seeing on prescription pads written, you know, so and so is safe to exercise their Second Amendment rights. So there's just a lot of wild things going on with that particular issue right now. So in order to address some of these concerns, as Dr. Gulrajani mentioned in the beginning, they worked on a resource document through the APA that tried to give some guidance to clinicians, not just about what these laws are, some of the outcomes that we just talked about, but also focusing in on the clinical situation. That was our goal with this work group. Problem was, and you could find that on the APA's website, or if you just Google APA resource documents, then it will take you to the list of them and you can read it at your leisure. The problem that we ran into, though, is that there aren't really great answers to a lot of these questions, or there weren't obvious answers. And so it was actually quite a challenge to come up with guidance for mental health professionals that was going to apply to people around the country. So I'll do the best that I can to kind of answer some of those questions as they relate to the clinical scenario I presented you with a few minutes ago. So can you request removal of the guns from your patients? That one is a little bit easier. You know, the answer in Maryland, DC, and Hawaii is like, yes, you can yourself go straight to the court. But in any other state that has an ERPO law, you can also call the police and report your concerns, and then they would be the petitioner formally, but you can still convey the information and get the process going. What if they're not the patient's guns? That usually, I guess it needs a little bit more study. My experience in reviewing these petitions is that it really doesn't matter whether they're the patient's guns or not, as long as the person is the one who has access to them. So I've definitely seen petitions where the police went into the home. They weren't sure who these guns belong to, but they seized them temporarily. And then they might not go through with that final hearing or the full ERPO process, because then they can get a hold of the person whose guns they are, and that person agrees to keep them safe. It's really only in the rare circumstance, for example, where you're worried about a teenager who has access to a parent's gun and the parent says, no, I don't agree with you, I'm not going to keep these safe. Like, that's probably the most common situation where you might actually need to invoke an ERPO rather than just giving the guns back to their rightful owner. How much clinical information should you give to the police? This is, again, ERPO laws are silent on this issue. There is no part of any statute that says, you know, as there is in child abuse reporting, that people have immunity from liability for good faith reporting. So the best advice I can give you about how much clinical information to share comes from HIPAA, which is like the minimum necessary. So you probably have to tell the police, of course, the patient's name, maybe where they live, what your concerns are about suicide or violence risk. So maybe something about their violence history, suicide history, and then what's been going on recently that led you to make this call. But you don't necessarily have to give them information that's more discretionary, you know, about diagnosis, treatment, psychosocial history that's irrelevant. So as much as is necessary to convey the risk and no more than that. If you're asked to appear at a court hearing, you should be prepared for that, because if you're the one who is conveying the risk to the court, there certainly is a likelihood that you will be asked to either testify or to provide records at this court hearing. I guess I will say, though, that across the board in all of the states, in the majority of cases, people don't show up to these hearings. And so the proceedings are just kind of terminated, or the judge makes a decision based on whatever information they have in front of them. And so it's not a given that just because you initiated an ERPO process that you will have to testify in a hearing. Should you continue to work with a patient whose guns you've been asked to remove? That one is really a clinical decision. As I mentioned, similar to any other situation where patient might be mad at you for a decision that you've made. So you can't just abandon a patient, but you also might want to do what's clinically appropriate for them, transfer them to someone else's care if that makes the most sense. And that's the kind of thing where you'd probably want to talk with a colleague or someone to figure out what to do. And then what if a patient asks me to write a letter saying that they can have their guns back, or perhaps that they didn't need to have them taken in the first place? There's actually a completely separate APA resource document that addresses that particular issue. But the bottom line is that if you don't feel comfortable doing that kind of assessment, don't do it. Refer the patient to a forensic psychiatrist or somebody else who has particular expertise. I've often found that psychiatrists who practice in the military have some experience with fitness for duty evaluations that in practice often mean fitness to carry a firearm. And so that might be a better option than hastily writing a letter or trying to conduct an assessment that you really don't feel comfortable doing. The take-home message of our APA resource document was really just that a lot of these important questions that clinicians are going to have about confidentiality, about liability, all those concerns remain really unaddressed at this point. And it's really going to take these next few years as the laws get older and mature to see through litigation or statutory changes whether some of these black holes are addressed. Because as written, the ERPO laws most of the time don't include physicians as the petitioners. They don't provide any kind of explicit exception to confidentiality or permission for a physician to report. And they don't explicitly provide any protection from liability, either for petitioning, that is reporting your concerns, or for not reporting your concerns. And so the best advice that we can give you at this point is to seek consultation, or as my residency mentor, Tom Grutel, would say, never worry alone. If you work in a hospital, there's risk management people, there are attorneys for the hospital, there are forensic psychiatrists, and this is the kind of thing where you definitely want to get consultation from someone. If we look towards the future, and again, I'll just wrap up in the next couple of minutes, where do we go from here? So my stance on this is that I am cautiously optimistic about ERPO laws as a suicide prevention tool. I think even though the data are limited, there is good evidence to say that people are using these laws appropriately when they're concerned that someone's going to harm themselves. I think I'm much more muddled about whether this is actually a tool to prevent mass shootings, or even not mass shootings, but regular old shootings or regular violence. I think that is still something that's going to need to play out over a longer time, because the mass shootings are so infrequent that it's hard to say that you've actually prevented something from happening. So I think more to come on violence prevention, but cautiously optimistic about suicide prevention. I also do like the idea that we're taking steps to disentangle mental illness and dangerousness. I like the idea that this is a legislative strategy that doesn't specifically target people with mental illness and assume that they're the ones who are responsible for most of the violence in this country, which, as I'm sure you know, is not true. So I do, as much as I've expressed reservations about how this works in clinical practice, I do think that this is potentially a really helpful tool. I think we're going to have a lot more data to analyze in these next few years. So I reported data from 5 different states, but I also told you that now there's 19 that have these laws, which means that in the next 5 to 10 years, we're going to see a lot more data, a lot more analysis of how this is working. And this is right now, I think, a situation where the advocacy on the ground around legislation is outpacing the research and the evidence. And I hope to see the research catch up. And my part in that, helping the research to catch up, is being involved now in a multi-state study that helps to compare the implementation in different states, the outcomes in different states, and the jurisdictional variations. So comparing apples to apples, basically. So our study has 6 different states, and we're kind of pooling all the data from, I guess it'll be probably about 5,000 or so ERPO petitions in total, and trying to see who's being affected across the country, and then whether we can glean anything that will help us then refine these ERPO laws or figure out how they best work in the future. So that study is ongoing probably for the next 1.5 years. So if I talk to you after then, I'll have much more interesting things to say about that. These references are the 5 main studies where I got all of the data that I presented about the outcomes and the evidence. So if you want to look those up, there they are. And then I will just say thank you very much for this invitation and for the opportunity to talk with you. And I look forward to hearing your questions.
Thank you, Dr. Kapoor, for such a great presentation. Looking at the numbers in the audience, clearly there's a lot of interest in talking about this and discussing this. And speaking about liability for physicians who do petition or otherwise make these kind of requests to law enforcement or courts, Dr. Narang had a very relevant comment in the chat. I'm going to read it out. Dr. Narang says, most of the time, I have a good discussion with patients and family members to discuss gun safety, especially during crisis and when the patient seeking is active treatment. One patient threatened and wrote stuff online when he did not comply with my recommendation, and I had to call 911 to help confiscate his guns as he was drinking, going through divorce and suicide, and was suicidal. He wasn't holdable to admit. That experience was witnessed by my medical students and resident, and they were visibly frightened. Next day, I had a bad review on health grades and a complaint to the patient representative at my hospital. Unfortunately, his complaint was taken very seriously, and I felt discounted by hospital administrators who did not understand my responsibility to ensure safety. Bottom line, it's hard to have people on the same page when it comes to guns and mental health.
Could not have said it better myself, that last line, that, you know, we come back to where we started, which is that a lot of these decisions are often really influenced by personal beliefs or things that maybe shouldn't enter into a clinical or a legal situation, but often do. I really appreciate you sharing that story, because I think it really illustrates the real dilemma for mental health professionals. You know, I think you could make an argument that there's an exception to confidentiality in a circumstance like that because it's an emergency, but then that's undercut by the fact that you're not hospitalizing the person in that moment too. So it makes it seem slightly less emergent. So I do think it's very tricky, and I'm dismayed to hear that hospital administrators didn't support you in what sounds like it was a really complicated and emergent decision that you had to make.
The next question comes from Dr. Zagaloff. She says, I imagine this could vary by state, but if someone has a firearm removed by ERPO and then applies for a job that requires a background check, what would that be discovered and what are the repercussions?
I think the short answer is that it does vary by state. Like, to my knowledge, there is no national database where people who have been subject to an ERPO go into. And then in terms of like, what are the implications? So the person, even if they are applying for a job that would require them to have a gun, they still couldn't purchase or possess one legally if it was within that year period. So that's often the impetus, for example, for police officers to voluntarily give up their guns in the situation rather than go through the ERPO process, because it will be a prohibitor then for being able to possess or purchase in the year following the ERPO.
We have a question from Dr. Steve Olson on the federal prohibition on research into gun violence that was lifted. Dr. Olson asks, were there other funding sources before the CDC ban was lifted? And what are the prospects for future research? Will this make a difference?
So I can only speak to my own experience, which is that we were able to get the study I mentioned at the end funded privately through the National Coalition for Gun Violence Research, or NCGVR. And they have been funding studies even before that CDC guideline was changed. There's also, I'm going to get the name wrong, but I'm pretty sure it's called the Educational Fund to Stop Violence, who funds a number of these studies. So there is funding out there. And I think particularly around ERPOs, which have become something of a hot topic in public policy and public health, we didn't actually find it that difficult, to get a pretty large grant to do this multi-state study. So I'm optimistic about where things are going to go in the future.
I had a question, Dr. Kapoor, for clinicians practicing in states where there are no ERPOs. Just by way of background, you rightly mentioned there was impetus for an ERPO law back in 2019-20. It allowed for family members and law enforcement officers to petition for gun removal, but there was no mention of clinicians. And that bill did pass our House, but did not pass the Senate. More recently, I believe another senator from St. Louis Park has introduced a bill, but it hasn't been voted on. Irrespective of that, physicians do have a duty and obligation created by other laws to prevent dangers and risks of harm. And so I'm curious, in light of all the mishmash of confidentiality, privilege, lack of ERPOs, what kind of advice would you have for physicians in states like Minnesota where there are no ERPOs?
So an easy question there, right? No, I think that the framework that you just presented is the framework that you're going to approach that situation. So you don't have the tool of the ERPO process, but you still have your clinical tools of, let me try and convince this patient to give the guns up voluntarily. Let me try and get the family involved to take them temporarily. There's also, even if you don't have an ERPO petition, you still, in most states, have an obligation, a duty to protect, the traditional terrace-off duty. So it may end up that you make a warning under that terrace-off obligation. It could be that you have a child abuse reporting obligation. So for example, if you don't think that a parent is appropriately storing firearms that a kid has access to. So all those other obligations are still going to be in place. and all your other clinical tools can still be used. This is really just one adjunct. And the more I think through the clinical scenarios, I think it's a smaller and smaller number of cases or clinical scenarios where I think you'd actually have to use the ERPO process. I guess the other thing I'd like to say is that I don't really care that much about whether physicians are named as petitioners in these laws, because I think for most clinicians, whether you're a physician, social worker, psychologist, it's practically speaking easier to call the police, report the concern, and then have the police officer do all the court proceedings with the ERPO. That, you know, in terms of taking time out of your clinical schedule, doing the paperwork, having the familiarity with the court process to begin with. I think that I understand the intent of wanting physicians involved in this, but I think that that can be accomplished even with law enforcement as the petitioner, and a lot of clinicians would actually probably prefer that.
Yeah, and that's sort of how I have witnessed it happen in the few cases that I've seen gun removal in, that somebody from the hospital will contact either the law enforcement or county attorney's office, who will then petition the court. Any other comments or questions? Would be interested in hearing anybody who's opposed to these laws. All right, I think with that, we can call it a wrap. Thank you again, Dr. Kapoor, and look forward to meeting you later in the day. Thank you, everyone, for attending.
Thank you.